Almighty God, we give thanks to you, the creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this house here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen, amen, namaste.
Oath or affirmation, announcements by the Speaker.
Honorable members, I have received communication from Mr. Ganga Singh, MP, member for Chaguanas West, who has requested leave of absence from today's sitting of the House. The leave which the member seeks is granted.
Bills brought from the Senate, petitions, papers.
The Minister of Finance.
Thank you, Madam Speaker. I have the honor to lay the following papers. 1, the consolidated financial statements of First Citizens Holdings Limited and its subsidiaries for the financial year ended September 30th, 2019. 2, the audited financial statements of InvestTT for the financial year ended September 30th, 2019. 3, the audited financial statements of MIC Institute of Technology Limited for the financial year ended September 30th, 2018. I beg to move that papers 1 to 3 be referred to the Public Accounts Enterprises Committee.
Honorable members, the question is that papers 1 to 3 be referred to the Public Accounts Enterprises Committee. All in favor say aye. Any against? The ayes have it. Leader of the House.
Thank you very much, Madam Speaker. Madam Speaker, I have the honor to lay the response of the Teaching Service Commission to the 14th report of the Joint Select Committee on Human Rights, Equality, and Diversity on Sexual Harassment in the Education Sector. Thank you.
Committees.
Member for Chaguanas East.
Thank you very much, Madam Speaker. I have the honor to present the following reports. Number 1, the 12th report of the Joint Select Committee on State Enterprises on an inquiry to assess the performance of the Community-Based Environmental Protection and Enhancement Program and its operations. Number 2, the 13th report of the Joint Select Committee on State Enterprises on an inquiry into the operations of the MIC Institute of Technology, with specific reference to the high dropout and failure rate of its trainees. Thank you.
Member for Mayaro.
Madam Speaker, I have the honor to present the 9th report of the Joint Select Committee on Land and Physical Infrastructure on an inquiry into the policies for the promotion of non-traditional methods of farming, including digital farming technology.
Prime Minister's questions, urgent questions.
Member for Naparima.
Thank you, Madam Speaker. To the Minister of National Security, with respect to the recent drowning of 2 foreigners at a beach in Kumana, could the Minister indicate whether there were any lifeguards on duty at the time?
Minister of National Security.
Thank you very much, Madam Speaker. Madam Speaker, firstly and very quickly, I would like to take this opportunity to extend deep and sincere condolences to the family members of the deceased who died on Sunday at the Kumana Toko Beach. At about 4 p.m., the wife ran into difficulty, and the husband, Trinidadians living in Canada, I understand, and they both disappeared under the water. So my condolences on behalf of the government and the people of Trinidad and Tobago to them. Madam Speaker, in 2015, lifeguard services were placed under the remit of the Ministry of National Security, and currently lifeguard services are provided during the hours of 10 a.m. and 6 p.m. at Losiro, Vesini, Quinam, Mayaro, Manzanilla, Salibe, Mathura, Salibe, Toko, Maracas, Tyrico, and Las Cuevas. And unfortunately, Madam Speaker, at the beach at which this horrific incident transpired, lifeguard services are not at this time provided thereat.
Supplemental, member for Naparima.
Speaker, we too would like to extend condolences to the families of the victims, who were persons who died. Could the ministers advise whether it is the practice to increase the number of beaches patrolled by lifeguards on holidays when large number of citizens visit our beaches?
Minister of National
As I
Security.
indicated, we have lifeguard services provided from 10 a.m. to 6 p.m. at the locations I identified on a daily basis at those particular locations.
Supplemental, member for Naparima.
Is it the practice to increase that at all, or is that fixed in stone when the demand increases on holiday occasions?
That which now subsists, Madam Speaker, and of course, this is subject to change as information and circumstances might warrant from time to time.
Member for Caroni East.
To the Honourable Minister of Health, could the Minister confirm or deny whether at this time there are any confirmed cases of COVID-19 infected persons in the country?
Minister of Health.
Thank you very much, Madam Speaker. Madam Speaker, information from CARFA as at March 3rd, 2020, reveals that from 6 member states, including Trinidad and Tobago, they received tests to conduct on 26 patients, and to date, including today, all tests so far have been returned as negative. Thank you very much, Madam Speaker.
Supplemental, member for Barataria-San.
Indicate if there was a suspected case of COVID-19, why was it transported to Port of Spain Hospital and not to the quarantine center?
Minister of Health.
Thank you very much. Honourable Member, as you know, even under your tenure during the flu season, all suspected flu cases will be dealt with at the hospitals. If the clinician determines that, clinically speaking, something needs to be referred to CORA, it will be done so. In this particular case with the Canadian, I am told by the Chief Medical Officer there was no suspicion of COVID-19. Therefore, he was treated as any other flu patient presenting to a public institution. What is happening, Madam Speaker, is that unfortunately there's a lot of panic going around. And, yes, but we have no cases here as yet. We have to make sure we act rationally and reasonably. Because what is happening, because of the panic, you are getting panic buying of masks in the private sector, which are now leaving doctors and nurses in the private sector exposed, because they can't get masks, and they need the masks more than members of the public. That is what I talk about panic. There's a need for concern. There's a need for heightened vigilance. But as leaders in the society, you must never succumb to panic. Because when you panic, your decision-making becomes flawed. So let us be concerned, let us have heightened vigilance, but never panic. Panic is a dangerous attribute which will not serve us well. Thank you very much, Madam.
Supplemental, member for Caroni East.
Thank you, Honourable Minister. Would you kindly consider giving active consideration to the establishment of a hotline for access to citizens who may consider themselves in danger by virtue of their symptoms, as is done in other countries now, so that more properly equipped personnel could go to their home and rather than them having to go to an institution?
As laudable as that may be, member, I cannot allow that as a supplemental question. Member for Barataria-San.
Honourable Minister, 23 politicians have been infected in Iran, and one close aide to Ayatollah Khomeini has died because of the coronavirus and the movement out of Iran because of the politicians. Would it be prudent to say that now is a possible time to curtail government travel as a result of those type of statistics?
Minister of Health.
Thank you. And Madam Speaker, at last week's Thursday's post-cabinet press conference, the Minister of National Security said just that the cabinet took a decision that all non-essential travel of government personnel will be curtailed as of last week, Thursday. It has now drilled down, I could tell you, at the Ministry of Health. I, this week, refused 2 requests to travel, one to Santo Domingo and one to Washington. So we have actively engaged that, and that has been done. Thank you very much.
Member for Couva South.
Thank you, Madam Speaker. To the Minister of Finance, based on statements made by members of the Bankers Association of Trinidad and Tobago yesterday, confirming that counterfeit polymer 100 notes have been in circulation since December last year, could the Minister state what is the government's plan to deal with this, given that one of the reasons for switching to the polymer note was to address counterfeiting?
Minister of Finance.
Thank you, Madam Speaker. There has been no statement from the Bankers Association that counterfeit polymer notes have been in circulation since December last year. That is misinformation propagated by a daily newspaper. I spoke to the president of the Bankers Association myself, and she indicated that no such statement has been made to any newspaper. What was told to a newspaper by a person who is in charge of security matters at one of the banks was that he saw a video on social media, which all of us have seen. Somebody created a video on social media saying, look, how, I am copying the notes. We don't even know if that video was real. We don't even know if it was fabricated. We don't even know if it was concocted. What we do know is that the Bankers Association never said that counterfeit $100 bills have been in circulation since last December. That is simply untrue. And what the Bankers Association have told me is that the issue of counterfeiting is a regular occurrence all over the world. People always try to counterfeit money. They try to counterfeit the old bills, and obviously in the future they will try to counterfeit the new bills. The good thing is that the new bills have far more security features than the old bills and are far more difficult to counterfeit than the old bills.
Supplemental, member for Couva South.
Thank you, Madam Speaker. Mr. Minister, taking into consideration that there was a headline in yesterday's newspaper, Trinidad Guardian, fake 100 notes. What is the government moving forward with its plan as it relates to the demonetization or issuance of polymer notes as it relates to $5, 10, 20s, and 50s, and so on? Could you advise this Honorable House?
Minister of Finance.
Madam Speaker, that is a completely different question, but I'm glad the honourable member brought it up. So a newspaper puts something on a front page and says fake bills. If the honourable member had read the story, Madam Speaker, what is this?
So,
what kind of behavior is that?
Member for Couva South, you've asked a question, and I'm certain you want to hear the answer. Minister of Finance.
If the honourable member had read the story said that the person who allegedly brought the alleged fake bills wished to remain anonymous. There's no source. How does one know the entire story is not a concoction? As I said before, Madam Speaker, through you, the security features on the new bills are far more robust and far better than the old bills. Counterfeiting is something people have tried since time immemorial, and they will try it again. However, the polymer nature of the bills, the clear, transparent window, the braille dots on it, and the multiple inserts and other security features make the polymer bills much more difficult to counterfeit than the old cloth bills. So the issue is not anything near to what the honourable member is suggesting.
Questions on notice, questions for oral answer.
Leader of the House.
Thank you very much, Madam Speaker. Madam Speaker, there are 5 questions for oral reply. We will be answering all 5. There are 3 questions for written reply. We'll be answering number 32, number 33, and we ask for a 2-week deferral for number 37. Thank you very much.
Number 37 is deferred for 2 weeks. Now call on member for point of pair.
Thank you, Madam Speaker. Question number 34 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
So could I just get some clarity? So 32 is deferred or something? 32?
This is number 34.
I know. Well, 32 is now gone to be returned. Yes. Okay, thank you very much. Thank you. With regard, the question is based on a false premise. The current arrangement with international fuel suppliers is a long-term revolving credit facility for the duration of the supply contract. For each cargo purchase, Paria is given 30 days credit. The 30 days credit starts from the delivery date. Various credit terms are applied internationally, and 30 days credit is one of the more common standard terms. In some instances, Paria stipulates in their contracts a minimum and maximum of cargoes to cater for projected growth in demand. But the bottom line is that the credit that is advanced to Paria after they receive a shipment of fuel is 30 days. But the arrangement with the supplier is long-term.
Member for point of pair.
Thank you, Madam Speaker. Question number 35 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
The average monthly value of foreign exchange used for the importation of fuel for domestic use is US $60 million. Of this amount, Paria is provided by Heritage Petroleum with US $40 million per month, earned from the export and sale of crude oil. In addition, Paria also imports approximately US $50 million per month worth of fuel to supply the regional market. However, this does not increase foreign exchange consumption, since regional customers pay for their fuel from Paria in US dollar currency.
Supplemental, member for Caroni East.
Honorable Minister, would you be kind enough to give us information? How many suppliers are there to Paria and what value, if there are more than one suppliers?
I would not allow that, member for Caroni East, as a supplemental question. Member for Faisabad.
Thank you, Madam Speaker. Question number 41 to the Minister of Education.
Minister of Education.
Thank you very much, Madam Speaker. Madam Speaker, the Ministry of Education has been advised that the use of cannabis and its effect on humans is taught in the pharmacology course within the BSc Pharmacy degree at the University of the West Indies, St. Augustine. Additionally, research regarding cannabis has been conducted at the University of the West Indies, Mona campus for the past few years. Given the embryonic state of cannabis decriminalization, there are no immediate plans to introduce courses on the medicinal use of cannabis at the Faculty of Medical Sciences, University of the West Indies, St. Augustine. One must be cognizant of the care and the due diligence required to ensure policies and guidelines are thoroughly outlined before the introduction of courses and the related issues, such as access rights and storage of the material itself. which would be associated with such offerings. The Ministry of Education is confident that the University of the West Indies will always seek advancements in program offerings and will continue to act in the best interests of the population. Thank you.
Supplemental, member for Faisabad.
For that answer, Minister, can you state if there's a public education program in schools with regards to the issue with marijuana? Public education program in schools at the present time? Or is there an intention to create?
I will not allow that as a supplemental question. Member for Faisabad.
Thank you, Madam Speaker. Question number 42 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, the working hours of the employees of the currently licensed office Transport Division of the Ministry of Works and Transport are 8 a.m. to 4 p.m. Monday to Friday. Thank you.
Supplemental, member for Faisabad.
Thank you, Minister. Minister, in view of a video that circulated suggesting that there was just one employee on duty on Friday, 3rd January 2020, and there was a significant lineup of the public waiting for service, can you indicate whether an investigation was conducted into this matter?
Minister of Works and Transport.
Madam Speaker, I did ask for a report on that video that was circulated. However, the indication was that there was a long line, but the line was for going to several different areas. Everybody wasn't lining up just for cashing. However, from time to time, we do have challenges with employees, not only at the license office, but in different areas. And what we are doing at the license office to eliminate that from happening going forward is, one, we are upgrading the cash register system, which will eliminate the cash books. That will shorten the time spent by the cashier. Two, we have submitted a list of employees to the controller of accounts who can act as cashiers in the event that there's a shortage in that area. And three, we are about to launch the kiosk at the license office, where you don't have to necessarily go to the cashier if you want to pay with links or very soon credit cards. You go to the kiosk and you do your transaction there. That will eliminate the whole purpose of having to go to the lines. Thank you.
Supplemental, member for Faisabad.
Thank you, Minister. Minister, can you indicate how soon you anticipate that this kiosk will be available?
Minister of Works and Transport.
Sure. Madam Speaker, as I said, we are in the process of upgrading the cash register system. The kiosks and so have already, that process have already started. And like everything else at the licensing office, we are modernizing the entire license office with the demerit point system and all the activities that takes place there. So I can give you the assurance that very soon you will see the activities have started, and I would say within the next 2 to 3 months, you will be able to go to the license office and utilize the kiosk rather than having to take the lines at the cashier once you're paying with credit card or links. Thank you.
Member for Faisabad.
Madam Speaker, question number 43 to the Attorney General.
The Attorney General.
Thank you, Madam Speaker. Madam Speaker, the Administration of Justice Electronic Monitoring Act No. 11 of 2012 was assented to in 2012. Between that date and September 2015, nothing was effectively done to implement the Act. Let me repeat that. Absolutely nothing was done for several years. Subsequent to September 2015, this government put in place necessary systems to allow proclamation. That included the establishment of the Electronic Monitoring Unit, the staffing of that unit, the occupation and outfitting of the office staff of the Electronic Monitoring Unit, a service provider engaged to provide a full turnkey solution, delivery, installation, commissioning, maintenance of that system, installation of the required hardware and software for electronic monitoring, the training of the staff of the Electronic Monitoring Unit, 300 electronic monitoring unit devices having been procured, an electronic monitoring committee comprising the relevant stakeholders to address the operationalization. The Electronic Monitoring Unit, in conjunction with the Advanced Programs Training Unit of the Trinidad and Tobago Police Service, conducted training workshops for the sensitization of police officers. Sensitization sessions were also conducted for probation services and the Trinidad and Tobago Prison Service. In anticipation of full proclamation by this government, we in fact drafted the regulations for operationalization. In the preparation of the regulations, we got comments from stakeholders, namely Judiciary and Ministry of National Security, and pursuant to those comments, it was identified that we needed to make certain amendments to the Administration Act, the Electronic Monitoring Act. We have in fact drafted those amendments. These regulations are subject to negative resolution. We intend to lay the amendments to the Act at the same time, in or around 1 week from now. So if I can repeat, absolutely nothing between 2011 to 2015, full operationalization, procurement, personnel, offices, software, training, stakeholder, GPS monitoring. We have got it done, Madam Speaker.
Supplemental member for Faisabad.
Thank you, Attorney General. AG, are you of the opinion that the electronic monitoring bracelets will be useful in the fight against domestic violence?
Attorney General.
Member for maybe seeing what we sent out in circulation. We have drafted amendments to the Domestic Violence Act, which specifically incorporate the use of corresponding bracelets. Persons who are the beneficiaries of ex parte or inter partes protection orders from the High Court or the Magistrates Court, as we have amended the law to allow that. We are proposing that the electronic monitoring bracelet for the person against whom the order is given will correspond to a unit which the person who is to be protected will have. So a proximity alert will alert the persons. Secondly, that ties into the judiciary, the Trinidad and Tobago Police Service. So I'm very grateful that the honourable member has apparently taken sight of the legislation that we have drafted. It's out in public circulation. We are working with the NGO and several entities on this, and we will ensure that that is done. God willing, the opposition will see it fit to actually support those amendments, because they have to date supported none of the critical amendments.
Request for leave to move the adjournment of the House on definite matters of urgent public importance.
Member for Caroni East.
Thank you, Madam Speaker. In accordance with Standing Order 17, I hereby request leave to move the adjournment of the House at today's sitting for the purpose of discussing the following definite matter of urgent public importance, namely, the vulnerability of healthcare workers with respect to patients suspected of or having the COVID-19 virus infection. The matter is definite since the World Health Organization has declared it a global epidemic, which is now affecting countries within the Caribbean area. This development poses an imminent danger to Trinidad and Tobago's citizens, with a more immediate danger to healthcare workers. The matter is urgent because healthcare staff are, at this time, inadequately prepared through a lack of policy direction, procedures, and information, including protection measures to deal with suspected and/or confirmed cases. The matter is of public importance because of the thousands of healthcare workers who, if unprepared, can unknowingly transmit the virus to its citizenry. Thank you, Madam Speaker.
Honourable members, I'm not satisfied that this matter qualifies under the standing orders. Members will take note that under urgent questions, matters were allowed involving the coronavirus.
Statements by ministers, personal explanations, introduction of bills. Under supplemental order paper, the Real Estate Agents Bill 2020 in the name of the Attorney General. Motions relating to the business or sittings of the House and moved by a minister. Public business, government business, bill second reading.
The Attorney General.
Thank you. Thank you, Madam Speaker. Madam Speaker, I beg to move that a bill entitled An Act to Amend the Constitution Prescribed Matters Act, Chapter 102, the Interpretation Act, Chapter 301, and the Judicial and Legal Services Act, Chapter 601, be now read a second time. Madam Speaker, it is absolutely true that crime is a very large, if not the largest issue in our republic. This has been the case for decades. In 1973, in constitutional reform discussions, the then Commission wrote of a state of affairs in Trinidad and Tobago which effectively described a panicked country besieged by crime, where persons feared for their lives on almost a daily business. Fast forward, more than half a century later, we are today in Trinidad and Tobago with a larger population having the same discussion. Governments prior to this government produced legislation in an ad hoc fashion. Indeed, no Attorney General prior to this government's Attorney General dared to publish a legislative agenda. The first item of business put into the Parliament in the current tenure of this government was the publication of a legislative agenda in a 5-year period, short-term, medium-term, and long-term. Other governments took the fight against crime by amending pieces of law. For example, as a question was just asked by the member for Faizabad, we had an Electronic Monitoring Act passed in 2011, assented to in 2012, but then nothing was done by the past government in the period 2012 to 2015. The same applied for the law in respect of DNA, data protection, sexual offenses, sexual offenders registry. Absolutely no form of operationalization was done. This government's philosophy of tackling crime in a manner that no other government has done has been based upon 4 premises. Number 1, plant and machinery. Number 2, people. Number 3, processes. And number 4, the law. And if you'd permit me to explain what that means. It is foolhardy, if not an exercise in insanity, to pass a law and then turn your back on it. If you don't have the place to operationalize that law, the machinery to operationalize that law, if you don't have people hired to do the work, if you don't have the processes by way of rules and structures and weeding out the difficult roadblocks along the way, and very importantly, if you don't have the law. That is why, Madam Speaker, this government has been able to pass law and operationalize it almost immediately. I'll give you the examples. Family and Children Division, a law which amended 19 other laws. A miscellaneous provisions on the back of that, which amended 23 laws. The Criminal Division, a law which created an entire division to deal with the criminal caseload in our country. Those are 2 laws which have resulted already in the opening of the Children's Court, the expansion of the Family Court, the creation of 25 courtrooms with judges, with masters, with registrars already in operation. The Criminal Division, where we took the criminal caseload, we said to the magistrate and the judge, stop sharing jurisdiction where you never talk to each other. We introduced masters of the court. We introduced rules of the Supreme Court in the criminal proceedings rules, and we have opened the Criminal Division. That is to be met with in a matter of mere weeks when we open the waterfront civil courts, moving the civil courts from the Hall of Justice to the waterfront. We will yield in total approximately, adding in the family and children's courts, by the month of April, all things being equal, this government will have opened 125 new courtrooms. Let me repeat that. We will have opened 125 new courtrooms. How do you give relief in the criminal justice system where you're crying out for relief if a trial takes 10 to 20 years? But, Madam Speaker, we went further than that. It wasn't good enough to create the spaces. We hired over 500 plus people to work in the respective divisions of the judiciary. Family and Children Division, Criminal Division. I want you to recall the name Watson Duke, a man allegedly in support of the public servants of this country, sitting in protest on the Hall of Justice steps to refuse to allow the birthing of the Criminal Division. That came and that went, and 500 plus new people were added to the judiciary, allowing us, Madam Speaker, to have the benefit of new masters, new magistrates, supported by 5-to-1 support staff, judicial research assistants, judicial support officers, other personnel, 5 people assisting each judicial officer from magistrate to court of appeal. Added further, we added in the criminal proceedings rules. Before that, you arrived at court, matter was dismissed, matter was adjourned. The member for St. Augustine would know this well. It was a long waiting line in the magistrate's court to arrive to be told, come back another few months later, a few years later. Madam Speaker, we added judge-only trials. The opposition told us nobody would use judge-only. Nobody charged with murder would use judge-only. I am pleased to say we have had judge-only trials where murder matters have been dealt with, one by way of acquittal, one by way of conviction, and the person convicted has not appealed, and the appeal is out. We have had judge-only trials for money laundering matters. We have had plea bargaining introduced into this country. We made history as a country. In a concluded case right now, the case of Vincent Nelson, Queen's Counsel, who admitted to guilt, was sentenced, and that matter has come to an end merely this week. Landmark decision of money laundering, the largest money laundering case in the history of Trinidad and Tobago, completed by plea bargaining. Madam Speaker, let me repeat that. The largest money laundering case in the history of Trinidad and Tobago, completed by a judicial process of plea bargaining. Madam Speaker, that plea bargaining, that judge only, the criminal proceedings rules, Madam Speaker, the processes of 5-to-1 ratio, that's what I mean by processes. In those processes, Madam Speaker, we look to the caseload. We said that it's inappropriate to have 146,000 cases in the magistrates' court every year. We looked at what comprised that 146,000. We said motor vehicle and road traffic, 104,000 out. April 2nd, the demerit point system goes live, and 104,000 cases in the magistrates' court go into the demerit system. I commend the Minister of Works and Transport for giving the people of Trinidad and Tobago some time to acclimatize to that law. And Madam Speaker, on December 23rd, 2019, we said in respect of marijuana cases, 8,500 per year, take them out of the 146,000. And that became law, yielding every Monday available for the use of judicial time as opposed to charge cases for marijuana. We went further. We said remove preliminary inquiries, 26,000 cases in the magistrates' court every year, and have them dealt with by the judiciary. And that, as soon as the criminal courts are birthed in April, together with improvements at the DPP's office, that will result in the 146,000 cases dropping to 8,500 cases. We hear the opposition speak about a plan. There is no plan to equal what I have just described. Madam Speaker, hence this bill. This bill appears short in measure, but it is deep in impact. This bill, Madam Speaker, addresses the concept of judicial resources. Madam Speaker, in treating with two matters, because this bill, even though it amends 3 pieces of law, it deals with 2 matters. The easiest matter to deal with is the amendment to Section 63 of the Interpretation Act. Section 63 of the Interpretation Act is the provision that says, if you have a law that says that you have regulations and you don't prescribe a breach of the regulations penalty, you're subjected to a whopping $500 fine. To avoid that ridiculously low fine, we now seek today in this bill to amend the Interpretation Act Section 63 and instead provide that you will have a breach of regulations being subjected to a maximum of $100,000 and a term of imprisonment not exceeding 5 years. That means that regulations that are breached will actually be caught by this. It'll be open to a judge for maximum consideration. So that's the easy one. Clauses 2 and 4 of the bill are what treat with the very powerful concept of judicial resources. I noted the leader of the opposition in her contribution on the last occasion at private members' bill borrowed a little fudge, took a little inclination out of what we are working on and started to speak about age of retirement for Defense Force. Too late, Madam Speaker. Too late, Madam Speaker, because this bill treats in first measure, before we get to that, with the judicial capacity. Madam Speaker, we as a government, in watching who is going to do criminal cases, because it's all well and good that we deal with the backlog, dropping the 146,000 to 8,500, moving judicial time around, increasing resources, but where are the judges coming from? We did 2 things, Madam Speaker. We did the amendments to the Family and Children Division Act, and we did the amendments via the Miscellaneous Provisions Act, and what we did is we raised the legislative judicial capacity in those amendments. What did we do? We said it is inappropriate, if you want to tackle crime, that you only have 36 High Court judges and you only have 12 Court of Appeal judges. And, Madam Speaker, we raised that 36 to 64. And, Madam Speaker, we raised that 12 to 15. More than that, we went to the Constitution and we widened the pool of resources available to Trinidad and Tobago. And we effectively included judges to be selected from around the Commonwealth, not just certain jurisdictions. The Bar of England no longer being the sole bar of consideration. But, Madam Speaker, we have a terrible situation anchored in sections 106 of the Constitution, 136 of the Constitution, in the Judicial and Legal Services Act, in the Constitution Prescribed Conditions Act. In those laws, Madam Speaker, we confine the age of retirement to judges to 65. So let me take you, Madam Speaker, to the Constitution. The Constitution is the supreme law of the Republic of Trinidad and Tobago. Chapter 7 of the Constitution treats with the Supreme Court, the Court of Appeal, and the High Court. Section 106(1) of the Constitution says, subject to Section 104(3), a judge shall hold office in accordance with Sections 136 and 137. Section 136 says, the holder of an office to which this subsections 3 and 11 apply, in this section referred to as the officer, shall vacate his office on attaining the age of 65 years or such other age as may be prescribed. Stick a pin, Section 54 of the Constitution, which tells us the degrees of entrenchment for amendments to the law, does not say anything other than we can amend this process of judicial age by simple majority. The matters of prescription springboard us, Madam Speaker, into the Constitution Prescribed Matters Act. That is Chapter 102 of the Laws of the Republic of Trinidad and Tobago. This act is a very simple act. It was birthed in September 1966. It's a very short act. It's 5 clauses long. In it, we have the specific Section 4, which has the retirement age of the Auditor General. Section 4, the age at which the Auditor General is required to vacate his office under Section 136(1) is 60 years. It provides a beautiful opportunity for us to include a new Section 3A, where we take the judicial age of retirement to 70 years. Why should we do that? What is commonsensical? What is important in that structure? Madam Speaker, we did an exercise where we went around the Commonwealth, and in getting to the Commonwealth, we looked at a number of jurisdictions. We looked literally, Madam Speaker, at the following jurisdictions: Australia, Bahamas, Bangladesh, Barbados, Belize, Botswana, Brunei, Cameroon, Canada, Cyprus, Fiji, Ghana, Guyana, India, Jamaica, Kenya, Lesotho, Malawi, Malaysia, Maldives, Malta, Mauritius, Mozambique, Namibia, New Zealand, Nauru, Nigeria, OECS, Pakistan, Papua New Guinea, Rwanda, Samoa, Seychelles, Sierra Leone, Singapore, Solomon Islands, South Africa, Sri Lanka, Swaziland, Tanzania, Uganda, Vanuatu, and Zambia. And what we found, Madam Speaker, is that on average, in the more developed jurisdictions, Australia, Canada, Guyana, Jamaica, United Kingdom, that the ages of retirement were up to 70 to 75 years. Indeed, the Caribbean Court of Justice, the age of retirement is 73, if I'm not mistaken. Our judges at present, Madam Speaker, retire promptly at the age of 65 and go to work in the Caribbean in the OECS. They work in Belize, they work in Bahamas, they work in Turks and Caicos, they work in Jamaica, they work in other jurisdictions. Our judges, viewed to be the most robust of judges in the Caribbean, the most experienced because of our caseload, our judges go instead to the other islands and we lose judicial capacity. Therefore, in continuation of the expansion of the criminal justice system in a way never seen by this country before, in a plan of action that no other government has contemplated, we come today to raise the age of judicial retirement from 65 to 70. I can tell you, Madam Speaker, there are many judges on our platform who are prescribed by another very deep concern. There are two types of judges that may serve on our benches: judges appointed by way of permanent appointment and judges appointed by way of temporary appointment. There is an unfortunate prescription which I intend to ask the Cabinet to remove, and that is where temporary judges can serve on the bench and immediately go back into practice. But permanent judges have a 10-year restriction on getting back into private practice. The recommendation which I propose to make to the Cabinet and to the country is to put a 3-year limitation only, so that we can attract young, bright minds to serve in judicial capacity and not be afraid that they'll be locked out of their profession. And Madam Speaker, I have drafted that already. I intend to move that forward for active national consideration so that we improve judicial capacity. That is why, listening to the Leader of the Opposition flirt for the first time with the idea of the age of retirement for the Defense Force, I said a little earlier was too little, too late. It's already under consideration. Madam Speaker, apart from the obvious common sense position of wanting to preserve judicial capacity, with the expansion in the number of judges, we have done something else. We as a parliament, aided only by one opposition member who had the courage to break ranks and say yes, and I'm talking about the member for Chaguanas West, one opposition member had the courage to break ranks with his leader and say yes to the increase in judicial pensions. Because you cannot ask judges to serve if their terms and conditions are less than what the market provides. So, Madam Speaker, that is one of the mainstay operations in clauses 3 and 4 of the bill before us today, Madam Speaker, as we deal with the issue of judicial pensions. And Madam Speaker, in clauses 2 and clauses 4. Now, Madam Speaker, there is another very important benefit inside of this bill, and that is in the reorganization of the definition of chief legal officer. Chief legal officer, Madam Speaker, was effectively in Section 2, in subsection 15, it was defined effectively as Master of the High Court, Chief Magistrate, Registrar, and Marshal. And Madam Speaker, what was an anomaly was that the Executive Court Administrator, the person who is effectively the permanent Secretary of the Judiciary, that person was omitted from the list of personalities. And why do I raise that, Madam Speaker? If we look to the Constitution Prescribed Matters Act, and we go, in fact, to the schedules attached to that, Madam Speaker, we will see, forgive me, it is not that act, it is the Judicial and Legal Services Act, Chapter 601, and we go to the schedule attached to that, and we note in particular the provisions of Schedule 2, the second schedule. You will note the Chief Magistrate, Master of High Court, Registrar of the Court, and Marshal, and the Court Executive Administrator, they are identified as being subject to the Chief Justice. Control and measure. In the Family and Children Division and in the Criminal Division Acts, which we passed and have been birthed and put into operation, we provided for an administrative arm of the judiciary for the first time ever. We provided for registrars of the court as opposed to clerk of the peace. That is up and running. And in this structure, it is notable that the Judicial and Legal Services Act did not treat with the Executive Court Administrator in the same fashion that we treated with the permanent Secretary of the Ministry of Legal Affairs, as it now falls under the Attorney General's office. And in treating with that, and in view of the executive functions performed by the Executive Court Administrator, we are now ranking the Executive Court Administrator, who is in charge of the administrative arm under the Chief Justice in that capacity of the entire judiciary in the structure that we have given. We are now lifting the terms and conditions of that personality so that the judiciary does not experience a constant revolving door where you cannot retain talent. Madam Speaker, that in effect covers all of the main objectives of this legislation. It is entirely opposite to the best interests of the people of the Republic of Trinidad and Tobago. It takes us into the zone of anchoring a judiciary that can perform by providing courts, 125 of them, by lifting the number of judges from 36 to 64 in the High Court, by lifting the number of judges in the Court of Appeal from 12 to 15 in the Court of Appeal, by raising the number of masters. The member for St. Augustine will know that the last government sat down and watched 2 masters of the High Court in operation. Today, we are on the way to 35 masters, having crossed 25 already. Who are masters? Masters are the people to case manage the case matters. We've reduced the backlog. We've taken 146,000 cases. We chopped out 8,500 in marijuana. We have treated with the motor vehicle and road traffic. We're chopping out 104,000 cases on April 2nd. When we abolish preliminary inquiries, we chop out another 26,000 cases, taking the magisterial caseload from 146,000 cases every year to 8,500. With 43 magistrates in 12 courts. Madam Speaker, the creation of courts that I've described does not include the Magistrates' Court in San Fernando, which is in the course of going out for being built right now, corner of Irving Park. Madam Speaker, my friend, the member for St. Augustine, knows that. It does not include the criminal division to be constructed where we're demolishing the old Magistrates' Court in San Fernando. It does not include the Rio Claro Court. It does not include the new Arima Court. It does not include the new Princestown Court. Those are hundreds more to come into effect under the next PNM government, which will preside in the period 2020 to 2025. Because no other government had the foresight to put those dots together? Nobody. They arrived with a little tweak and an amendment to the Firearms Act. They arrived with a tweak and an amendment to this piece here and this piece there. They operationalized nothing. Full of old talk, Madam Speaker, as opposed to plant and machinery, people, processes, and law. Madam Speaker, this is good law. This is forward thinking. This is operational soundness of a type that nobody opposite has thought of. And I thank the Cabinet of the Republic of Trinidad and Tobago and the Honorable Prime Minister for agreeing that this is prudent for us to raise the age of retirement for judges, keep judicial capacity, keep the learning that Trinidad and Tobago has on our shores, increase the terms and conditions for the executive court administrator so that the judiciary is better armed to manage itself. And I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Constitution, Prescribed Matters Act, Chapter 102, the Interpretation Act, Chapter 301, and the Judicial and Legal Service Act, Chapter 601, be now read a second time. Member for Old Butch West.
Thank you. Thank you, Madam Speaker, for recognizing me as I rise to contribute to this bill, the Miscellaneous Provisions, Age of Retirement of Judges Interpretation, and Chief Judicial Officers Bill 2019. Madam Speaker, before I proceed, I would like to deal with some of the issues the Honorable Attorney General has just expounded and, we would say, expatiated. And if he has called out all these different laws, Madam Speaker, why is it that the people of Trinidad and Tobago are ducking and hiding and running for their safety? You see, Madam Speaker, for those who do not know, for the uninitiated, Madam Speaker, one listening to the Honorable Attorney General would believe that we have the best judicial system and it's the role model for the world to emulate. One will believe that the magistrates have all the resources at their hand. One will believe that the judges are even happier. Madam Speaker, one will believe that the masters of the court have rooms where they could go and sit and do sufficiency hearing. And the registrars of the court will have all the support services that they need. Madam Speaker, and most importantly, the people of this country will believe that the wheels of justice are oiled and moving swiftly, so there is the rule of law. But the Attorney General is totally out of sync, Madam Speaker. When he speaks, Madam Speaker, it's almost like peacock-like, Madam Speaker, where the unfolding of the plumage so he can exhibit a kaleidoscope of colors. Madam Speaker, what is that? That is just glitz and glamour and no substance. Glitz and glamour and no substance. The Honorable Attorney General, Madam Speaker, spoke about the waterfront. The waterfront, Madam Speaker, having what, 60 civil courts? You are moving the courts from the Hall of Justice, taking them to the waterfront. But I want to remind the Honorable AG, what was the purpose of that waterfront? It was under the Manning's administration, it was his 2020 vision to make that waterfront what is called the financial hub of the Caribbean. Madam Speaker, we had a joint select committee where we had brought Master Maurice Allen before us, and we were looking at the adequacy of the facilities in the courts of Trinidad and Tobago. And what did Master Allen say? She said very rarely the judiciary is engaged when you have to procure buildings and outsource buildings to conduct court hearings. I am asking the Attorney General, have you engaged the judiciary? Have you asked the judiciary what is the design and layout you want at the Hyatt waterfront? Madam Speaker, when you're doing a courtroom, I just want to educate the other Honorable Attorney General, is that a courtroom must never have a central column. And I'm inviting everyone to go to the waterfront. We sat there and see how many columns run in zigzag. And you're going to put civil courts there? The same thing happens in the San Fernando Supreme Court. And I will give you an example, Madam Speaker. I was cross-examining a witness, one of the courtrooms at the Supreme Court. There is a central column that is snug right in line with the witness box. And as I'm cross-examining the witness, he's moving right, I am moving left. And we are going zigzag. He's playing games with me. Madam Speaker, imagine a witness, a lay person, and I'm going to quote for you what he said to me. He said, "Ma'am, it have too many posters here." Madam Speaker, we are talking about a layman telling you there are too many posts in the courtroom. And this is what we have happening because you're not engaging the judiciary to say how you want, because there must be a clear line of sight. The Honorable Attorney General spoke about Princess Down Court. Madam Speaker, up to now, that has not been used because there's an earthquake and the building perhaps collapsed. You can't use it, and he's boasting, as I say, peacock-like, boasting about Princess Down Court. Then he boasts about the court in San Fernando Magistrate Court. That's another court. For 5 years, the attorneys in San Fernando, they have to pine away, the magistrate running from Medina Court to the High Court. Lunchtime, junior sex system. The judge has to pull up all his papers, exit the court. So you have a magistrate leaving Medina to go to the Supreme Court to conduct the second, the fourth, and the fifth and sixth courts. That is what we have happening. And if one were to go to Freeland Street, you would see the land space that was earmarked, Madam Speaker, to do a magistrate court. 5 years. I am wondering if it's the same way, Madam Speaker, if you could eyeball 30 grams of marijuana. That's the same way. So we are not going to see it happen, Madam Speaker. This is what you call glitz and glamour. Madam Speaker, a court cannot act or perform its duties, courtrooms. They need what you call support services. You have ancillary elements. So if you are going to set up those 60 courts at the Hyatt waterfront, you have to have separate planning unit. You have to have a court research and statistical unit. You have to have court protocol and information unit. You have to have an information technology unit, plans and building and equipment unit, a court reporting unit, records management unit, court library service unit. Honorable Attorney General, through you, Madam Speaker, do you have all this? Where would all this happen? What is it? You can't tell me that all this is existing, and we'll use from the High Court, or the Supreme Court here, Hall of Justice, to deal with 60 additional courts. It just would not augur well. The Honorable Attorney General spoke of backlog of cases. That's why we want to increase the age of judges. Where do these backlog come from? Where do they start? Where are they initiated? They start from the magisterial level. And if you are not doing anything to pull these matters through the magisterial level, Madam Speaker, then you are what you call, when you thing top in mud? Spinning top in mud. That is what happens. Because you have a circle. You actually have a circle. When you have matters keep adjourning at magisterial level, for the want of a prosecutor, for the want of a defense counsel, you cannot find files. You cannot find the prisoner. because they keep the prisoner in a dock and they cannot find his file. So they put him back in a loading bay and send him back in remand yard. What about the 100 persons the Attorney General rushed into Parliament to do cannabis bill and say 100 persons cannot pay $500, so we're going to take them out? They're still pining away inside there. What happened to that? Oh my God, one, you have two, they're still sitting there because they still can't get the $500. Madam Speaker, let me deal with this backlog and what some of the judges say, Madam Speaker. A particular judge said the magistrate court is the abandoned child, and the judiciary has to take it back into its fold. That was reported in Sunday 6th, Newsday 2019. She also said that the magistrates are trying to make a difference. They're trying hard, but they do not have the resources at hand. So what do we do? What about when we go to the magistrate court, Madam Speaker, and the Attorney General talk about court pay? How many persons have used court pay to pay maintenance? Madam Speaker, my office is next to the Medina Court. One Friday, I went into the court 2 weeks ago. Lots of people forming zigzag. They're outside of the courtroom, standing almost to the road. Some come and sitting on my staircase. I say, oh, today lots of traffic matters. Nobody answered. You know why? Because a lot of child fathers outside there waiting to pay maintenance. The Attorney General said he's going to put kiosks in every court. Where are the kiosks except kiosks, Madam Speaker? Where are the kiosks? So nobody using the system. He also said, the Honorable Attorney General, that we are going to have lotto booths. Where child father going to pay maintenance when he could play away? Huh? That is not being used. So, Madam Speaker, this is just what you call fanfare. Everything is what you call honky-dory, but nothing is working. The wheels of justice are spinning so slowly, Madam Speaker. People are totally fed up. That's why there's no sustenance of the rule of law in this country. Madam Speaker, if you want to increase the age of judges, we have no problem, you know. Absolutely no problem to increase the ages from 65 to 70. But one has to understand what would be the mental capacity of these judges. We have to look at the mental capacity. Because, Madam Speaker, as we age, Madam Speaker, we have physiological changes. So the things we can do at 40 years, we cannot do it at 70 years. So, Madam Speaker, what happens is that you get something called presbycusis. You get something called presbycusis where you cannot hear. So who would know that more than the member for Rima? Presbycusis, Madam Speaker. You see?
Member, I advise you not to go there, please.
You cannot hear, Madam Speaker, and then you have what's called presbyopia. You cannot see. So those are some of the things you have to engage these persons who are judges. You're going to extend their age limit from 65 to 70. 65 to 78. So what you need to do, Madam Speaker, is that perhaps you need to have a group of doctors, because just as the public at 65 years, they have to go when you're going to renew your license. They have to go to a medical practitioner.
Okay, members, I am having great difficulty in following the contribution of the member of Urupuch West because there is a lot of crosstalk going on. So I'll caution all members to abide by Standing Order 53. And member for Laventille West, I saw you on your legs, but what I would like to say is that if all members, abide by the standing orders, I think it may lessen the need for you to jump up on your legs. So I think we're going forward, and everybody will abide by Standing Order 53. Please, member for Rouge West.
Thank you. The Honorable Attorney General spoke about judge alone trials, Madam Speaker. And God forbid us if a person who is a defendant decides to go for a judge alone trial, and that person the judge doesn't have all his mental faculties intact, Madam Speaker, what happens? The person's life and limb and liberty is subjected to the sole discretion of the judge. So that is something serious, Madam Speaker. So judge alone is an issue because the Honorable Attorney General said some persons have opted to have no jury. They don't want to be judged by their peers. They opt to have judge alone trials. And that will be a challenge for both the judge and also for the litigant. Another issue, Madam Speaker, when we keep the age of the judges to 70 years, what about the upward mobility of judges? We have 65 sitting in the High Court. Judges sitting at the High Court, they have a legitimate expectation that they will go up to the Court of Appeal. So if you have those sitting in the Court of Appeal not moving, you are not creating a space or you're not creating that opportunity for those at the High Court to move upward. And the simple question I'm asking, have you asked the judges if they want to work to 70 years? After they have all these problems to undergo in this judicial system, many of the judges who I've spoken with are totally frustrated, Madam Speaker. You think they want to work for an additional 5 years and foregoing family time when they do not have the resources to work with? We have some judges cannot even get paper to print judgments, and they are tired of dipping into their pockets to buy paper. So are those judges prepared to work for another 5 years? What about the younger ones, Madam Speaker? That younger, what you call senior counsels. Senior counsels would have worked 10 to 15 years, Madam Speaker. They would have built their homes and purchased their Mustang and Prado and so.
Swiss sports car.
And what happened, Madam Speaker? They would want to go to the bench. But if you have 65 judges sitting now in the High Court, there's no room now for senior counsels to move to the High Court. So you do not have the upward mobility of lawyers and the judges. Then, Madam Speaker, if you were to increase the age of the judges, are you going to have a caveat? Are you going to place a caveat with the age of those judges? Because after 70 years, are you saying, okay, you can no longer head commissions and you could no longer head inquiries? So you could have room for the younger ones. We could recall what happened to Justice Venter. Justice Venter had to resign from the Integrity Commission. He had to take up a new instrument to go back to the court. He had to go back to the court to get another instrument to be appointed as a judge, complete his judgments, resign again, and come back and get the next instrument to come back and head the Integrity Commission. You see, Madam Speaker, so you need to have younger people, younger judges who are articulate, who are bright, because we have many young, bright judges who will want to do these things. Yeah? Madam Speaker, I understand there's also a 10-year ban for judges. So after they have resigned or retired, at 65, they are not allowed to go in practice after 10 years. So you also should have addressed this and say that we would deal with that 10-year ban. So we should have done it simultaneously. So at least after the 65 years, Madam Speaker, they could go back and practice, because some of the pensions and the monies that they receive is not commensurate with the rate at which things and prices are happening in this country rising, which is called the cost of living. It is not commensurate. So these persons may want to go back to practice. So we have to address that 10-year ban. We also have the issue, Madam Speaker, of artificial intelligence in the courtrooms. We are in the fourth industrial revolution of the world, where we're talking about robotics, where we are talking about ICTs, we are talking about artificial intelligence. And what you have happening, Madam Speaker, in Estonia is artificial intelligence has replaced judges in some cases. In the Netherlands, we have artificial intelligence used in court management. It assists judges in their judicial capacity to select relevant jurisprudence. They help highlight arguments by the parties, or they create arguments to be used in judgments. And even in sentencing, my friend, a member from Mayara, is reminding me of that. Even also, Madam Speaker, in the US,
23 years. And I have never, even when the UNC was in government, unfortunately, talk about under the UNC, because I just find it intellectually soft and stupid. Because it is well known, or it ought to be well known, that criminals pay no reference to who is in power when they're ready to prey on the next victim. I read in today's paper, Madam Speaker, by way of a minor example, a woman is at a fruit stall in the Maracas area, I think yesterday or day before. She's gone there to conduct. And criminals armed with automatic weapons have sight in that food stall of a man who they had an interest in. They open fire in an attempt to deal with that man. And the woman fell to their violence. 2 persons died, the man and the woman. And when I read that this morning, I said to myself, I wonder if these criminals asked if PNM in government or UNC, who under? Foolishness. Having said so, the state, quite apart from any political party, quite apart from any government, because government is only a part of the state apparatus, has a responsibility to protect its citizens from that kind of outlawish behavior. And in that regard, work is being done, but I would like to see a lot more in certain respects. But we are responding to these outlaws by establishing a criminal justice system and a judicial system to respond when they are arrested and brought for resolution before these institutions of the state. That's what we are doing. And it cannot be doubted that in respect of that responsibility of the government and in respect of that responsibility of the state, that a tremendous amount has been accomplished in the last 4 years. To quote the Attorney General, he has done things, this government have done things that they never even thought about. And that's a fact. That's a fact. And by way of elucidation, in terms of this concept of under, we had a case, and the Attorney General made passing, and I should equally make passing reference to it, where former senior counsel Nelson pleaded guilty before court under modern legislation, plea bargaining, and the court dealt with that matter yesterday, imposed a substantial fine on behalf of the people of Trinidad and Tobago. But that crime for which he was sentenced yesterday took place under the UNC. No, it's not relevant, but I'm just using the word under. Under the UNC. A former Attorney General under the UNC. And a former chief servant and former senator under the UNC in the same crime. But I wouldn't dwell upon it, I'll move on. So this concept of under, I don't even feel I want to hear it in this parliament again. It is foolish. I would learn in my own constituency, much to my pain and chagrin, another young man lost his life within the last 48 hours. And one of the people living in the neighborhood where this incident took place explained to me yesterday, this young man had come from outside of the district, and it was a case of mistaken identity. We'll never know. The police are investigating the matter. But the word on the ground is he was taken for someone else. So the problem there is not the good work the Attorney General and the government has done. It is the behavior of citizens who find themselves in possession of illegal and deadly firearms. But the state has a responsibility to find every one of them firearms and take it and take those who possess them too if they could find them. And I would like to see more done in that regard. I know that the police are working, exerting maximum, well, not maximum, but great efforts. And I would like to see a little more energy to go, because guns are physical things, Madam Speaker. Yes. And they are somewhere, and they could be found. And I would like to see the entire police service dedicate all of its energy in the next 6 months to finding those things, so as to make the environment a little more safe and a little cleaner, as we did politically in 2015 by coming to government. We made Trinidad and Tobago a cleaner place. And we intend to keep it so later in 2020. You agree? Yes. Madam Speaker, the member was so trifling, she started to speak and spoke about the suitability of the waterfront. The Attorney General has been at pains to say, we've had a shortage of criminal judges. We've had a shortage of criminal courts. We've had a shortage of criminal law practicing attorneys. As a consequence of those three states of affairs and other issues, the criminal justice system was running like molasses going up a wall, slowly and ineffectively. The Attorney General said, listen, we are vacating the Parliament. We occupied those rooms since 2009 until the PNM came to office and rebuilt and refurbished this beautiful edifice, and we returned to this place. Those buildings are now, that building is now available for courts. So we came up with the decision, the government, to remove the civil courts from the Hall of Justice and to let them take place and residence at the waterfront. The judiciary, an independent arm of the state, led by the very dignified, learned Chief Justice, and their technical teams would have visited the waterfront on many occasions, and it could not have been occupied by the judiciary unless they agreed with it. So I want to say to the member for Oropouche West, whatever she may think of those buildings, it's a pronoun. Whatever the member for Oropouche West may think about those buildings, the one thing the Attorney General and this government could say is that it is occupied by the judiciary on the say-so acceptance and agreement of those who speak on behalf of the judiciary. So, Madam Speaker, they are satisfied, and the member for Oropouche herself now is nitpicking, looking for issues, as the UNC has been doing in their desperation, in their barrenness, looking for issues in this and across Trinidad and Tobago to raise alarm over. Failingly so. So what we now have is the Hall of Justice to be dedicated exclusively or largely to criminal courts and the administration of criminal justice. In that regard, the Attorney General quite properly boasts that we now have 64 rooms at the Hall of Justice on Knox Street dedicated to criminal justice. And he told us to supplement that, as the Minister of Health tells us. Creating a hospital and putting beds is one thing, but beds require personnel, nurses and doctors, and diagnostic facilities. Am I correct?
Correct.
Someone like a doctor?
Correct.
So the Attorney General is saying that those rooms are now available to administer the criminal justice system. And to support those rooms, like supporting the beds, we have increased the judges from 37 to 64? 36 to 64. Yes. And the staff, to support these judges, each judge now has a staff of 5 persons to support his work or her work. That's significant improvement. That is improving the processes. And we are here with an installment of improving the law, Madam Speaker. As we have improved the plant at the waterfront and on Knox Street. So the formula, as the Attorney General has been saying, is a question of plant, is a question of people well-trained and highly motivated, is a question of process, and it's a question of law. That's the formula we have been adopting, unknown to them, because they are only guided by wickedness. The government and the party we represent is known in Trinidad and Tobago for nation building, institution building. So the measure before us today may seem simple to simpletons, but it is another installment in the whole business of institutional strengthening and building to respond to the criminals on behalf of the law-abiding people so that they'll get a quicker day in court and justice would be served in accordance with biblical dictates and societal expectations. And I would like to take this opportunity in this regard to congratulate the learned officers of the court, justices of appeal, brand new, Mr. Justice of Appeal Kokram, Madam Justice of Appeal Wilson, Maria Wilson, and of course, well-known, Ruth C., multi-skilled, multi-talented, but legally sound and morally upstanding, Mr. Justice of Appeal, Malcolm Holdip. I would like to take on behalf of all of the people of Trinidad and Tobago, and certainly the people of Laventille West, to extend my congratulations to them and my confidence on behalf of the people that justice will continue to be well served. These measures here today, this measure is really simply to increase the age for retirement of our judges. And the member for Oropouche West had the temerity, the gall, the gumption, the bold-facedness in what I considered to be an attack on senior citizens in Trinidad and Tobago, unwarranted. A moment of age discrimination. The member blandly assumed that because you are age 70, you must be dumb. So she questioned their mental capacity, not taking into account that alcohol does worse for some people's minds than the age 70. But she would celebrate those who may partake in that. Yes. The regular and abuse of alcohol might be more damaging to someone's brain than acquiring age 70. So I reject any suggestion that people in Trinidad and Tobago or the world are necessarily deficient because they get to age 70. Huh? Yes, and while doing so, she disregards the fact that the member for Naparima
Until West, while I would allow a certain amount of she, because it follows naming the member properly, I'd like you to please watch that in your speech.
I would watch my pronouns carefully now. The member for Naparima. I'm obliged. Madam Speaker, just for the public record, I am sure the Attorney General, in his very lucid, wide-ranging, well-studied presentation here today, would have alluded to it. But just for the record, let me ensure that it is recorded that the Supreme Court, recently constructed Supreme Court of the United Kingdom, the retirement age is 75 years. I have just had a look, and there are several judges at the age of 72, 73, 74, the Supreme Court. The Privy Council, similarly. And the Supreme Court of the United States is very instructive. They enjoy tenure for life.
People in the 80s.
The Constitution of the United States says, and I quote, that all judicial power is vested in the Supreme Court, which is the highest court of the United States of America. They have tenure for life, member for Oropouche West. And I'll share with you, if you didn't take time to look at it. One Supreme Court judge, Ruth Ginsburg, Ginsburg, she started out her career, well, she joined that court in 1993. She is 86 years of age as we speak. Stephen Breyer, he started in 1994 on the bench. He is 81 years of age. Stephen, yes, he's approaching the age of my friend. Samuel Alito started on the bench in 2006 and now aged 69 years. And in fact, the records of the United States show that some of the judges of the bench would have served for as much as 36 years. And of course, human things as they are, life doesn't always last, and there's always room for upward mobility. So the member for Oropouche West, wondering what would happen when we increase the age of judges' retirement to 70, whether there'll be upward mobility. She assumes that no one will resign, retire, leave, perish, as human beings do. So, Madam Speaker, I would like to commend the measures before us. And I would like to say that our Caribbean Court of Justice, the CCJ, what's the retirement age there? 73 years. 73 years. That same Caribbean Court of Justice that my friends on the other side signed on to, not in its original jurisdiction, but in its appellate. Yes, not in its appellate jurisdiction, but in its original jurisdiction. That same court, which is now housed on Charlotte Street, between Charlotte and Henry Streets in the city of Port-au-Spain, where the UNC in government fought in the Caribbean community, demanded, negotiated to have the headquarters seated in Port-au-Spain. That same court, which the United National Congress supported all the way through, argued for, held up until the government changed. That is what Cemetery Edos does. Ignore that. Yes. The members' front yard was a cemetery. So, Madam Speaker, that same Caribbean Court of Justice, which the member for Siparia is on the public record of this country as saying she will not support, and because she could provide no solid, arguable, sustainable, intellectual argument, found herself the member for Siparia saying she cannot support the Caribbean Court of Justice because it did not reflect the ethnic composition of Trinidad and Tobago. And when I looked on the composition of the bench, I saw all flavors. Today we have Mr. Justice Peter Jamada, Justice of Appeal, on the Caribbean Court of Justice. And I would like to ask the member for Siparia whether she changes her position. She has changed her position since that time, since his appointment.
Your government, and we hold the same position.
Trust you.
We don't trust you.
I anticipated that level of emptiness as an intervention from the leader of the opposition. I would not have undignified my presentation by allowing it. But, Madam Speaker, I still would like to know from the member for Siparia, now that she may be satisfied with the ethnic composition of a court, whether a court's decision is on the basis of racial consideration. Whether she will support the Caribbean Court of Justice now. And if she will, I will urge my team leader to abort this debate, bring the criminal justice law in front of the parliament, and let's get on with the business of the people of Trinidad and Tobago. So, Madam Speaker, no, I don't want another fit of unsoberness. Madam Speaker, I am being disturbed and perturbed by the member for Oropouche West and the member for Siparia. And the very ghostly and ghastly member for Naparima. I'm sorry.
Member for Untitled West. I would caution you so that you don't run afoul of the standing orders with respect to how you refer to other honorable members. All right, and I also want to caution you with respect to Standing Order 48.1. You've got some liberty and so on. Let's get back to the matter at hand, please.
I'm indeed grateful for your guidance as always and as ever, Madam Speaker, and for which I thank you. So, Madam Speaker, I entered this debate, as I indicated from the very top, merely to ensure that the record would adequately reveal the sense of goodwill and the sense of intellect and the sense of thought and the sense of nationalism that should emanate at all times from this honorable House and not reflect without attention the frivolity that was fed to us here by the member for Oropouche West. And having done so, I trust adequately, Madam Speaker, permit me to return to my seat. I thank you.
Madam Speaker, it is truly a delight to return to the Red House, and this is my first speech here on the return. But in this period of Lent, may I suggest to the member of Laventille West that a dousing of water may not have been sufficient before, but that he should really attempt to get some holy water, because I do believe there is goodness deep within but well hidden from us. He cannot help but personally attack, in fact, very logical and germane issues raised. And I shall not call him a DIC, distractor-in-chief, because that is what this is. My learned friend from Oropouche West spoke on very important matters. And the brightest star on the PNM bench, of course, the Attorney General, and I warn him, because their tradition is that the brighter you are, the quicker they will take you out. So that all the great work that you have accoladed up onto yourself, the government, on behalf of the government, beware of those who compliment you, because they will be bearing not just compliments, but glittering swords. So, back to my learned friend from Laventille West. The most obvious lack of his presentation is the understanding of what the court system is about. And if it is that we do not understand that confidence in a court is the lifeblood of a judicial system, then you would have abdicated any sense of responsibility to the members of your constituency and to the people of Trinidad and Tobago. When jibes are shot at a member for Cypria, and speaking of the Caribbean Court of Justice, I think taking in its solitary isolation, you may think that you've scored a point or two. Just the opposite. One of the basic failures of a society that has inundated itself with criminality is when people lose respect and confidence. And I dare anyone in this chamber to say that you hold total confidence in the institutions of the state of Trinidad and Tobago, and in particular, the judiciary. What an orgy of errors, defamatory by nature, and certainly deserving upon the actions of those who hold high office. But before I get to that, let me start from section 137, because I will show you why many in the society, including myself, will not support the Caribbean Court of Justice. And it has nothing to do with the racial composition, and it really pains me that my learned friend would have brought it to that. There are more fundamental issues in terms of the substance of the court and the foundations of the court system that germinates those who populate it. Let us look at the irony of ironies. Our present Chief Justice, a very intelligent man, but against whom serious allegations have been made. And I'm not here to add to it, but to try in some way put a light as to why it is that persons are very suspicious of our judicial system. And I will not go through the details of the allegations against the goodly gentleman. He is our Chief Justice. And if you shall have your way, he shall be the Chief Justice of Trinidad and Tobago for another 10 years.
Member for St. Augustine, I'll just, caution you with respect to where you're going with this. Remember, we're not talking about any conduct about any judge here. Okay, we're talking about expanding the age limit. Okay, please.
And in expanding the age of service also brings into sharp focus the mechanisms and processes for removing judges before the time of their legal retirement. And now we are moving the legal retirement to 5. And if we are to take a very insulated, artificial approach to this debate, then we might all sit and just say, you have the majority, go ahead and vote. But we need to understand what we're dealing with here. Because I have been called, I have been spoken to, I have been told to ask the Attorney General who asked for this. Thank you for answering it, and I take you at your word. But there is a belief out there that because the waters have been so muddy, that natural progression from the High Court to the Court of Appeal naturally will take it to the CCJ or to the other international august bodies in relation to certain persons that water has been so muddy that they cannot go, and therefore require now a furtherance another 5 years. And if it was that easy, by the stroke of a pen, as I'm sure you wish it was, because an election is impending and you wish for another 5 years, but you cannot do so by coming here and voting for it, the people will have to vote on that. But there are office holders, and I am saying this from many intelligent people who've asked me these questions. Is this now another, what shall we say, coziness of the administration with the judiciary? No, don't say, come on, let me tell you why. Because in the public domain, and with the vintage of several days, not months, not weeks, and not years, we had the ignominy of a prime minister being required or requested by the Association of Lawyers in the country, the Law Association of Trinidad and Tobago, that represents, shall I say, and I'm hesitant to say the conscience of the practice, but a very important institution of the country, requesting of the prime minister to exercise his mind as to whether he should trigger Section 137. It is entirely within the prime minister's domain, but it went to a point where the prime minister, in his decision to not trigger, went ahead and muddied the water, is that the term they use?
Madam Speaker, Standing Order 48-1, please.
Member for St. Augustine, I uphold the objection. So please move on.
Ignoring the irony of ironies, that the act of Section 137 is a highly political and completely political act. So,
I upheld the objection. So I am not allowing the discussion about the impeachment and Section 137. Please.
I'm grateful that I'm done with that point. I think the point is well made and well understood by the thinking persons in the society. But, Madam Speaker, I want to say I have no deep philosophical objection to the raising of the retirement age. And in particular, not just the judiciary, but as the learned member and former Prime Minister of this country indicated on a prior occasion, for members of the armed forces. 45, yes. I wish I was 45 again. But let me tell you, you see, Mr. Attorney General, on a prior occasion, I had cause to use, in joke, of course, a term I almost call you a perennial larcenist, and I'm not repeating that here. But what you do not remember or do not know, because your colleagues may not have informed you, is that the whole process of raising retirement age in this country under the direction of the leader of the opposition, then Prime Minister, had already been started with a member for Chaguanas East. In fact, we had had consultations. I remember being invited to one in St. Augustine, and thank you for that invitation, where the place was just flooded with handsome men and beguiling ladies who, unfortunately, had already attained the age 65. And as Minister of Legal Affairs, I was tempted to go and check and see if the birth certificates were real, because they did not look anything like what you would have known age 65 to have been. I agree with you. People are much healthier. They are much fitter. There's something about age, it is really just a number. But we are dealing with a number here that is crucial. So that it suggests that we on this side do not understand the need to embrace those who are more mature than us and to ensure that their professional lives can be extended because they have tremendous value and worth as we proceed, is really to not know the truth. We had started that process, Attorney General. And as we proceed, just to tick off a few other things, the impression was certainly given today that the legislation for electronic monitoring was all that was done. But in the short term that I was at Ministry of Justice, we had identified a flaw in that building to house not just that, but the Office of the DNA Registrar and so on, a host of other things. I will not pollute this dilute this discussion here with all those fundamental truths that the staff at Ministry of Justice and the Ministry of the Attorney General certainly will know. Thank you very much. But, Attorney General, I want to say that attempting to move the age of retirement from 65 to 70 is a good move. Good move. But you have started, again, from the wrong direction. As busy as you are, let me just put this thing in refocus. The first thing, and I know it is a matter of a rule that could be easily changed, and if it is easily changed, let's do that first. You complain, and rightly so, because the member for Laventille West, I know he will not want to be a judge, and many others won't want him to be. But, for the reason that, there you go, that is the PNM, that is the mantra, jail everybody, not PNM, jail everybody, not PNM. And that is why when persons in the society, yeah.
Member for St. Augustine.
And that is why many good efforts are now being seen through the prism of jail everybody other than PNM. And there is legitimate cause and reason for that belief because we have a long history which we've spoken about before, and I may come to some of them. But the important thing, Madam Speaker, is that we are moving the age, and I'm making the point. This 10-year limitation really has no grounding in anything real anymore, because under our very Constitution, and maybe it's important to put a little context, the reason I believe that the 10-year limitation had been put was from an era when judges were held in high esteem, when there was a deification of persons who held that office as they were so superior in terms of judicial ability, legislative knowledge, and a capacity in themselves, and also the interlocking network that they would have had, that they would have been given an unequal advantage over others when they return to the bar to practice. They believe that their brothers and sisters will have given them favors, or at least be seen to do so. And that was an era when we all believed that justice must not only be done, but must be manifestly seen to be done, which we apparently have forgotten in this society. And that is why that 10-year limitation, in my view, would have been important then. But in the very Constitution, there was a provision to allow for temporary judges. And we had wonderful persons who said, you know what, in service of our nation, I shall go forward. We had the magnificent Pamela Elder, and I want to say condolences. Today I just came from her mother's funeral, a wonderful lady, Ursula. She died, and I came from that funeral. But Pamela Elder, Gilbert Peterson, and a host of others went forward because they knew that they could have gone, served their country for a 3-month period, and returned to the bar and continue their work. There are many, not necessarily only young, but very able lawyers who wish to do these things. Maybe for a year, Attorney General, maybe 3 years even 5, as you've donated yourself to the politics. And I have a tremendous loss, but tremendous gain in terms of my ability to have contributed, and I thank the member for Superior for that opportunity in government to do that. So I think that is something that we must immediately eradicate, by the stroke of a pen if it need be, to say remove this thing about 10 years. Because that is a terrible bar. Even judges who have recently retired at age 65, who do not wish to leave these shores, their options are extraordinarily limited. And they pine away sometimes becoming embittered because the little salary they would have had in the past, not salary, the pensions, much improved now, certainly could not have seen them through. And we had the awfulness of a former Chief Justice, and we've heard these stories, who could not have practiced, other judges with tremendous ability, and they pine away and just disappear, and then you hear that they've passed on. Let's deal with that almost immediately. Attorney General, if you could do it today, please. So that is an essential issue. Now, this 70-year issue, my learned friend from Oropuch West, my friend couldn't understand that as people age, there are changes, sometimes for the better, and sometimes for the worse.
Cognitive changes.
All sorts of things. To become a judge or be a magistrate, there is a serious process. I understood from some source, and Attorney General, you let me know if it's true, that candidates recently who applied for higher office in the judiciary all failed. And I mean now they're already in the judiciary, but couldn't do the promotional exams satisfactorily to move forward. And they all failed. Are we to suggest that because you're a judge and approaching the swan song of your career, that you automatically are qualified to go for another 5? Why is it that if the Minister of Works is here earlier, and I know we have a new traffic regime in, why is it then that at a certain age, I think it's 70, remember for Faizabad, that you need a medical if you are to renew your driving permit? Is that? 65. So you give a man the requirement that he driving a single car, that requirement, but you give to a man or a woman, you know what we don't really, we say judge. Do we know what the real power of a judge is? Or a magistrate? A judicial officer has the power and authority to change your life, member for San Fernando East. And as Laventille West warned us, don't give him that power because he will jail everyone. A judge has the power to take your property and give it to someone else by our order. And thank God for the Privy Council. I will probably come to that in a while from my own personal experience. A judge has the authority, by the way they conduct a criminal case, whether judge alone or with jury, that determines the verdict in that case that could lead to a death sentence being imposed by that judge. Let's understand this. One human being put on the robes, legal training, passed the exams, went on the bench, you are now a judge, we call you my lord or my lady. And you have the power to say unto a person found guilty before you that the sentence of this court is now that you be taken from here to a place of confinement where you shall await death by hanging. Chilling words. That is the power of a judge. Not only that, judges have the power to determine the outcome of an election. The very democracy is dependent on the court sometimes. And not wanting to invade your ruling. I am not. But I'm saying that the society is looking to see now in an election year and an election past how courts have responded, who are the personalities involved. You always find out who is the judge, who is your quorum. Come into that. Constitutional reform is a must. So these are important things. And when my friend called me and said, who asked for this? Why they want another 5 years? I said, don't make it personal. This is for everybody. He said, don't be so naive. How come, the question was posed to me, and I shall just pass it on for those who have the ability to answer it. An executive court administrator, is that a judicial position? No. Is that a judicial position? No, that's the point. Yeah, thank you, Attorney General.
Thank you. Honorable Member, in 2003, they cleaved the two streams. They created a judicial stream and a public service stream. And the Executive Court Administrator properly falls under the judicial stream, under the JLSE functions. And it is so labeled in the second schedule to the JLSE Act.
And that brings me to the point. Because the very germane foundation upon which the Attorney General started off, is about basically getting more judges to do case. This court administrator doesn't do case. It's an administrative function. What is the specific criteria and qualification that we now want to move that person out of the regular public servant who shall await the day, whether with glee or with sadness, of retirement, and put that person in the same category of a high court judge or a court of appeal judge? Thank you.
We're specifically not moving that person to the category of a member. We're moving that person to the category of a PS administratively. So it's far from the judicial salaries or positions. This is just ranking the PS of the judiciary with the PS of the public service and nothing more.
And the PS, unless I'm to be corrected, retires at what age? There you go. So do not say for a moment, Attorney General, that you're moving them to a PS level and then tell me you're giving them 5 years more than a PS. And thank you very much. You have your right, your option to wind up. No, well, please. No, let me.
Of retirement, 270 for the CEA. That stays at 65. That's not happening.
Most grateful for that. So that we now are in a position where we have persons who may be fit as a fiddle, sharper than, and very nimble-minded and everything at the age 65, but there may be others in that group who may require more attention. And I would want to suggest, first of all, Attorney General, and I'm just asking this rhetorically, this is voluntary, isn't it? It must be that if I wish to retire at 65, I can do so with full benefits. I would like you to put that on the record. Or do I have to wait to age 70 so that I can retire with full benefits? I'm not quite sure, and I want clarity on that. What is wrong then for those persons are attaining that age to go through a certain level of, I don't want to use the word examination, but testing, to ensure that all cylinders are firing in order and in time? That is all. Simple matter. Popular assessment. Nothing, what is wrong with that? In fact, the irony of it is that I understand the judiciary has a school of judicial education, not for us, but for the judges themselves. Do judges in the Court of Appeal participate in that? Do judges at the lower rank participate in it? If the answer is yes, well then, should we not at the higher end, because a lot of law, when you and I went to law school, have changed. And sometimes we practice in a certain area, and we have a bit of specialization in that, but the entire platform otherwise has moved in a different direction, and sometimes important that we, reassess where we are. So I think that is a very important factor. Now, the gorilla in the room. How do we choose judges to begin with? I had not thought much about it in years past. I took it as granted that the law had been on our books for so long, and it was good. But we must always be alert to our environment. Those who are not alert to the environment, from cavemen to now, will be eaten by the saber-toothed tiger. And the saber-toothed tiger that we have today is the lack of confidence in our judiciary. What is the experience that this country has had when a chief magistrate is appointed as a high court judge?
Member, again, I am not going to allow you to discuss this, both on the basis of Standing Order 48.1, and I believe with respect to what you're talking about, those matters are sub-judicial. I'm not going to allow it.
But let us then go to what the law says. The law in this country says that the Judicial and Legal Services Commission shall be comprised of the first person as chairman, a Chief Justice, without name. This is what our law says, and we're dealing with law here.
Member, as I said, I'm not allowing on Standing Order 48.1 a discussion about the appointment of judges. This, what we're discussing here, has nothing to do with the appointment. You're already a judge here. What is before us? I'm not allowing a discussion about the appointment of judges on Standing 48.1.
But forgive me, but the Attorney General raised the point of hiring new judges. And rightly boasted from 30 to 60-something. And therefore, this is relevant to this debate opened by the Attorney General, with all due respect. So not wanting to traverse, trespass, or anything like that, I'm making the point that, yes, I am making a very simple point, right? And for those who do not wish to get good points, well then, that is a matter for you. But it is for you. It is now my duty as a conscientious member of Parliament to express my views on matters I consider relevant, and if you find and you've ruled certain things, 48.1 and whatever, but I will stay with him.
Which I've done.
Sorry?
Which I have ruled.
Yes.
I have ruled on Standing Order 48.1. So please proceed on another point.
I'm making the point that in hiring new judges, when one looks at the history of the age of the hiring of judges, and this is the point, Attorney General, you have judges, very capable, competent persons, from many parts of this world, I imagine, who will come, and possibly made judges in Trinidad and Tobago, bringing their families here, and taking up residence here, in their 30s. Understand this. So let's do some maths. You have a young judge, 35. He has 35 years ahead of him or herself as a judge with the necessary security of tenure. And therefore, we have to be very alert, because the age sometimes is a necessary filter for those who have not come up to scratch. And that is why it is necessary to look at this thing in reality and in totality. That if you do not have a system that will scrub out those who do not come up to what is required, and what is the system we have? Almost an impossibility. We've had the history of Justice Crane, where impeachment proceedings had gone forward, of Chief Justice Sharma, and lately, and I'm very aware of not treading there, but the point is simply this, that sometimes, Attorney General, you know this, people interview brilliantly, they pass the exams and they put them in a position and they turn beasts. Totally not fit for purpose. And how do you deal with that? Therefore, the whole selection process is critical. The entire process for discipline must be revisited. Public law has so dramatically changed with judicial review that it is sometimes, in the eyes of the average Trinidadian, impossible to fix wrong things, especially in high office. I'm not suggesting that. I'm saying that we have to revisit holistically, not just this important bit of legislation moving a 5-year from 65 to 70. But if we're going to tinker with, and this is dealing with the tenure of judges, we must do so with a vision that at the end of it, we, the people of Trinidad and Tobago, must breathe a sigh of relief and say, finally, something is being done to fix the wrongs of the past and prepare for a better future. So, if we do not deal with the section 136 and 137 and make it far more, what shall I say, reflective of the needs of the day. You know, I had cause many times in the court to be told about what's the relevance. And I realized, with all humility, when a person doesn't see the relevance, there are two reasons. One, either they're irrelevant, or two, they just don't have the capacity to see relevance. And we sometimes confuse memory with intelligence, right? Relevance is the outcome of intelligence, because and that is why we have multi-directional education today, not just singular, so that when you have a person who is versed in medicine and in economics and in nuclear physics, sometimes you will find a combustion point where these things come together, and you find something that they could stoop all they want, but creativity comes from that. So when I hear section 48.1, I first of all check myself. But rest assured that if I check myself and I find, I will try to convince.
Madam Speaker, Standing Order 48.1, please.
There we go.
That relevant? That relevant?
think it's the right of any member to rise on any standing order. But I would want to caution the member for St. Augustine, because I think it is the Speaker who rules on relevance. And therefore, before you stand to continue, any member is entitled to raise any standing order. It is the chair that rules. And therefore, while I may try to appreciate what you're saying, it may have a reflection on the chair. It may not be intended, but what I'm saying, it may have. So, on the basis of the standing order that was raised, I therefore uphold the standing order. So continue on some other point.
And perish the thought for a moment if there was any reflection on this. I'm speaking about those who use the 48.1 to interrupt. And in the courts, I will tell you there are many times when you're about to break the witness, you hear all sorts of objections and irrelevance and so. I pass that stage, you know. So let me just make the point here, Madam Speaker, that this issue has to be looked at holistically. I've already made the suggestion to the learned Attorney General to remove the 10-year restraint on the ability to practice in the courts, but there's much, much more. I think it is wrong for a Chief Justice to help pick his team. It is not that.
And I'll just take this opportunity to remind us all to ensure that our devices are on silent. Member for St. Augustine, again, I stand on Standing Order 48.1 and also on Standing Order 48.8. And I will ask you to move on to another aspect. If I have to rise on that again, then I will have to invoke another standing order.
I'm not too sure which that is, but I feel almost, no, I wouldn't say threatened. I'm never threatened. But let me just say this, that we need to look at really a reform in the process that we get these judges to the point of their departure, either by retirement or by removal from office for good cause. So, Madam Speaker, you know the member for that.
Member for St. Augustine, your original 30 minutes are now spent. You have 15 more minutes to complete your contribution, if you so wish. Please.
I was stunned, and rightly so, by a statement from my good friend. People, I'm very fond of him, you know, from Laventille West. And when we sat on Joint Select Committee on National Security, we had a tremendous relationship, and I know that continues out. No, I shan't speak to you about this, Oropuch West. I know you East, you have your own experiences. But when I heard this august member from Laventille West make the pronouncement on the Hansard, which he says is a matter of record for posterity, you know what he said? He said criminality does not have anything to do. And to better let me better closely reflect what he said, that criminals do not care who in power, whether it's PNM or UNC, right? Where is a member for Port of Spain North, St. Anne's West? He's left the country. So that when we hear the most corrosive statements, corrosive to the very fiber of our democracy, that criminality is fueled by the politics without any cogent evidence to support it, you ask yourself, why are these statements being made? Is it not really to undermine the very democracy? When associations are made with persons who would have met, would have spoken with, and to suggest directly, if not very insidiously, that there's collusion to facilitate murder and mayhem in the society without the highest level of evidence, and then suggest...
Madam Speaker, Standing Order 48-1 again. What is that?
You're lacking in intelligence.
Okay, so a number of things. Remember who sucked his or her teeth? That is considered unparliamentary. Yeah. Member for St. Augustine, I uphold the objection. Please move on to another point.
My friend from Laventille West said certain things in this parliamentary chamber. Am I towards the press me what when you don't hear? I am not a victim of press excuses. I heard you. And you suggested...
Member for St. Augustine, I upheld an objection. I've asked you to move on. And I have ruled. Kindly move on.
My friend also said that criminals don't care who in power. But what was the campaign of 2015? Didn't you promise a PNM campaign to deal with crime in the country? And therefore, if the politics has no effect either on crime or crime on the politics, then what was your whole campaign about? They see they don't understand the power of words. The power of words eludes some because it may be convenient when it puts a certain complexion on things and very inconvenient when it does so another way, and therefore to be avoided. And that is why it is very important what we say here, that we really understand it is really for posterity and must be said with a sense of authenticity and belief in what you say. So I congratulate any effort to deal with crime fighting. But my friend from Oropuch West made very important points on that. You have in the arsenal available to you extraordinary powers under the law to deal with criminality. And I take no, what shall I say, no comfort. I take no joy, in fact, just the opposite, to say, with all of that, Attorney General, against all the work that you have put in, something has gone terribly wrong with the crime situation in this country. And if we figure that we could tinker with things and put it on the book without putting it on the ground, if you think that you could create manifestations of hope in your mind, but without putting it into the hearts of the citizens, then you are bound to fail. Why is it, in the face, after the People's Partnership government gave to the protective services, and in particular the police, 600 vehicles when there were very few working ones before, and crime went down? What do you say?
Madam Speaker, Standing Order 48-1, please.
Member for St. Augustine, I'll give you a little leeway with this, but I'd ask you to tie it back to what we have before us in the bill. I'll give you a little leeway.
Could I ask my lady's guidance then? When colleagues say things in the parliament, are we at all debating, or are we just dealing with the sterility of the legislation before us and therefore not answer the issues that have been raised? Because, you see, this, I do not know whether the population pays much heed to what my friend from Laventille West says. I don't know. But the Attorney General, I know people listen to him. And they dealt with it, they opened with this. And therefore, if I can't close with it, I will take my seat. And let it be said that my friends can do certain things and we cannot respond to it. And that is what I will be feeling in my heart. Unfortunate, but that is how I will feel hurt, that I am not treated as equal to my friends on the other side. Because I take the view, life is a passing thing. Whether you're 73, member for Naparima, or you're 33, member for San Fernando East. The positions you hold are extraordinarily temporary. Trinidad and Tobago has a long history. We took our independence 50 odd years ago. But my hope and ambition is that what we do, my God.
For St. Augustine having a difficulty in appreciating the line. An objection was raised, I ruled on it, and I asked you to please continue, but be cautious. I'm now hearing a totally different line that, in my view, and I think I have that authority, it is completely irrelevant. So I stand here on Standing Order 48-1. I will caution you to proceed relevant to what is before us in this debate.
I'm most grateful. But as my friend from Karen East knows full well, if one has to bowl a ball, there's a runner. And that if one doesn't put things in context, one doesn't understand it. So having regard to the very little time I have, I shall not develop that point today. But rest assured, it's a necessary one about Parliament and how we interact with each other. The Attorney General said that in very due course, 25,000 cases shall be removed from the court system. But somebody sent me a footage from TV6 where the Attorney General made that statement, and then the Director of Public Prosecution said, hold on, you can't do that. You have to resource me. And I know efforts are being made to resource the DPP's department, because it cannot be. You have a car with 4 wheels and you pump up one tire and the other 3 flat. Because what you will have is a good running tire, but the vehicle will not move well. And the development of the points made by Oropuch West was exactly that you cannot lift one side, you have to lift all sides. And I know the task is huge. I know the task is difficult. But unless you do the basics, for instance, giving paper to the court, giving transcriptionist, we know all of those things. But the most significant thing that we are here today to debate is whether we shall give more time to judges. I think I speak for my colleagues that we support that. But there are necessary implications to that, necessary fixes that can be made to ensure that we do not just do something out of context. And if we have to give 5 more years, then do simple other things, so that you do not have to have persons from all over the world who may not be able to, in their own homeland, have the reputation or so to get a job there, to come to be a judge here. When you have persons like Jaron Joseph, Evans Welch, masters in the court, when I say masters, advocates, who may very well want to serve as judges, but are imperiled knowing that if they sit as, as a judge, not as a temporary judge for a year or so or more, that if they do not find favor in that, they cannot return for another 10 years. So let's fix that today, please, if we could. So, Madam Speaker, I am really troubled that if I have troubled you, but I will take my seat now and rest assured that the respect I have for the Parliament of Trinidad and Tobago is one grounded in a faith and in a hope that the population will look upon all of us and say that we are all treated fairly and equally. I thank you very much.
Member for San Fernando East.
Thank you very much, Madam Speaker. Madam Speaker, let me start off by saying that the member for St. Augustine, in his contribution, fell below his usual standard today, Madam Speaker. And Madam Speaker, what was most stark about the member's contribution today was his inability to understand his very own irrelevance. Madam Speaker, what he does not understand is our use of 48-1 is the only standing order we could use to prevent him, as you, Madam Speaker, prevented him from going down the road that he wanted to go down, which is to talk about confidence in our court system and confidence in the judiciary. Because we understand on this side, Madam Speaker, that they on that side have a reputation for breaking down institutions in this country. And that was the standing order that we had to use.
What institution we breaking down here?
Well, so, member for Carinese, may I now? Member for San Fernando East, I'd ask you to apologize, retract that, and please continue.
Madam Speaker, I withdraw, Madam Speaker. And I apologize to them on the other side, Madam Speaker. Madam Speaker, the member for St. Augustine asked who asked for this piece of legislation, and the AG said that he did. And then the member wanted to go down a road to insinuate that on this side, we are wishing for a particular judge or judicial officer to stay for a longer period. But Madam Speaker, allow me please to quote from a document of the Law Association of Trinidad and Tobago, report of the Committee on Judicial Appointments dated June 18. And at page 44, Madam Speaker, under the paragraph treating with recommendations, paragraph 5, number 21, let me just quote. The committee considered the question of the retirement age of judges, which is currently 65 years, and formed the view that there is a persuasive case for increasing the mandatory retirement age to 70 years. And the member quoted that the Law Association of Trinidad and Tobago, in his words, was the conscience of the profession. So, Madam Speaker, just to put on the record that this is also a recommendation of the Law Association of Trinidad and Tobago. Madam Speaker, the member for Oropouche West also spoke about this backlog of cases starting in the magistrate's court. And I heard it on the radio coming up to Parliament. And I wondered, Madam Speaker, whether the member for Oropouche West was absent when we decriminalized cannabis, Madam Speaker, when we abolished preliminary inquiries, and when we decriminalized road traffic offenses, with the effect of decreasing the backlog in the magistrates' courts and increasing the efficiency in the judicial system. And Madam Speaker, I have to congratulate the Honorable Attorney General, the Prime Minister, and the Cabinet of Trinidad and Tobago for putting
55B, repetition.
Yeah, that's true.
Please proceed, member.
Thank you, Madam Speaker. I'm responding to the member for Oropouche West, Madam Speaker. So I put on record my congratulations to the Prime Minister, the Attorney General, and the Cabinet of Trinidad and Tobago for putting forward the most comprehensive package of reforms to the judicial system in Trinidad and Tobago, Madam Speaker. Madam Speaker, the framers of our Constitution put in place constitutional arrangements to provide for the confidence, trust, and independence of the judiciary. So, Madam Speaker, we go back to how our judges are appointed. Judges are appointed under Section 104. Judges are appointed by the President on the advice of the Judicial and Legal Services Commission. And with respect to tenure, Section 136 tells us that judges hold office until the mandatory age of 65. And apart from the mandatory age of 65, a judge may only be removed for infirmity, whether mental or physical, or for misbehavior. And Section 137 prescribes the way in which we remove judges for those reasons. Madam Speaker, from the days of law school, we all knew that once you're a judge for life, or until at least your retirement age. Judges enjoy the greatest security of tenure. And it is not by mistake, Madam Speaker. It is with the rule of law in mind. Because, Madam Speaker, to maintain the rule of law, fundamental to that is an independent judiciary. Madam Speaker, a judiciary shielded and free from external pressures, a judiciary free from conflicts of interest because they routinely hold very powerful individuals and governments to account. Madam Speaker, the judiciary recently had to pronounce on an election petition, Madam Speaker. And in all the texts, you see that a judiciary must not be dependent or beholden upon the executive. And Madam Speaker, in the last 4 years, we know that the judiciary must also be free from pressures from members of the opposition or former members of the opposition.
4 and 6, please.
What about pressure from the government?
Come on. 48-6.
Overruled.
Thank you, Madam Speaker. Madam Speaker, there's a person called Devant Maraj who is on the record.
Leave there and continue, please. Member, I have overruled the objection. There's no need to justify it. Please move on with you.
Thank you very much, Madam Speaker. Madam Speaker, only Section 37, only through incapacity and misbehavior can a judge be removed, and that is the way the framers of the Constitution designed it. So, Madam Speaker, with respect to the age requirement, the framers of the Constitution must have had certain considerations why they would have put it at age 65. And, Madam Speaker, obviously, the most obvious one was declining capacity. Declining capacity, Madam Speaker, I suppose at that time, the state of healthcare, the state of science, persons approaching the age of 65, it would have, Madam Speaker, at the age of 65, persons would be approaching the age of declining capacity, and therefore that mandatory requirement would be seen as justified. But, Madam Speaker, not in this day and age. Not in this day and age with the advancements to healthcare, with the advancements to science, persons, technology, persons who are at age 70 are just in their prime. And, Madam Speaker, on our benches here, we have the prime example in our Prime Minister of performance and leadership. And, Madam Speaker, I would even go as far as to say, Madam Speaker, I would even go as far as to say that the member for Naparima appears a bit sharp, although he has declined some capacity since exiting the bowels of the PNM. But still, Madam Speaker, he presents some sort of sharpness. So, Madam Speaker,
You mean it's a bowel movement?
Continue, please, member for Sanford.
Thank you very much. So, Madam Speaker, that argument goes out the door, Madam Speaker. And quite frankly, Madam Speaker, in practice, a small country as ours, we cannot afford to lose the resources, the intellect that judges present, especially when they approach their prime between the ages of 65 and 70. And in any event, Madam Speaker, to debunk the arguments from the member for Oropouche West, if they become afflicted with declining capacity, mental or physical, Section 137 provides the mechanisms for removal in that case. So the argument is really, well, not an argument. Madam Speaker, there's also the argument that in placing the mandatory age at 65, our constitutional framers wanted to give opportunities to younger appointees, because in the understanding that younger appointees to the bench, they would bring a more modern level of thinking, a more contemporary level of thinking. And, Madam Speaker, that is a fair argument. But, Madam Speaker, the retention of judges between the ages of 65 to 70, the movement of the mandatory age of retirement, will not interfere with that at all. And in fact, what that would do, Madam Speaker, is to provide the opportunity for greater succession planning on the bench and mentorship. Because, Madam Speaker, I'm not calling names, but recently there was a judge who fell below the standard of judges with certain utterances on social media. But, Madam Speaker,
I'd caution you, remember the provisions of Standing Order 48.8.
Thank you, Madam Speaker. But it was just to put forward the point of mentorship, because those social media utterances no longer occur. So, Madam Speaker, I appreciate on behalf of the members of San Fernando East, the constituents of San Fernando East rather, to place my support to this piece of legislation. I would encourage the members of the opposition not to judge judges by their own declining capacity. And, Madam Speaker, with those few words, I thank you.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, I'd like to thank my learned colleagues, the member for Laventille West and the member for San Fernando East, for so very capably dealing with very significant issues by way of response. Indeed, the contributions of my learned colleagues were rooted in the law, that if my learned colleagues had bothered to read the law, they would have been gathered in the right direction. The member for San Fernando East made it a very easy task, in particular, as did Laventille West, to make a very short reply in this debate, and I propose to do that. I thank the honourable member for San Fernando East and for Laventille West for pointing out that with respect to the #1 issue coming from Oropouche West and also St. Augustine, that is the issue of age of retirement and the position of what can only be a very unfortunate journey by my learned friend from Oropouche West, the position of the questioning of the state of mind of people as they get older in this jurisdiction, which I don't associate myself with. That can be dealt with. Unsoundness of mind and unsoundness of body are dealt with in the Constitution of the Republic of Trinidad and Tobago, and I quote from section 137. A judge may be removed from office only for inability to perform the functions of his office, whether arising from infirmity of mind or body or any other cause, or for misbehavior, and shall not be so removed except in accordance with this section. It is not as complicated a process as that involving the highest office holder in the judiciary, but it is nonetheless clearly contemplated in law. I say that that was the main point for Oropouche West because, regrettably, gerontophobia, the fear of age-related self-degeneration, or geroscophobia, hatred or fear of elderly due to memento mori, came sharply to mind. And I want to caution my learned friend from Oropouche West, who I have great and fond regard for, that the UNC's platform of not supporting judges at an older age really ought to be resisted. We on this side believe that the mechanisms of court are clearly managed by the Constitution. We have no fear that the judiciary is going to fall into any difficulty as a result of age. To put onto the record, in answer to the member for St. Augustine, who asked, where did this request for the increase in the age come from? It came from me as the Attorney General in my recommendations and in my research as to how to improve the capacity for criminal justice reform, particularly in my work at the Caribbean Financial Action Task Force. Other attorneys general in the Caribbean, in particular Rhonda Lee Braffett-Knowles, who's the AG for Turks and Caicos, also AG Sam Bulgin, who's the AG for Cayman Islands. Those two attorneys general boast on a constant basis how well the Trinidad and Tobago judges are doing there. Mr. Justice of Appeal Humphrey Stallmeyer, Mr. Justice of Appeal Stanley John, several of our judges appellate judges in particular, do very well up the Caribbean, and I thought it prudent for us to raise the age of retirement so that we can hold on to that. Madam Speaker, a few quick points. The prospect of accepting the submission from Oropouche West. Oropouche West's submission was that senior counsel who may be interested in occupying the bench will not have capacity because 64 judges are in occupation. Let me just break it down quite simply. That is a submission based upon judges being immortal and never retiring. Because you obviously have normal course of attrition, of retirement at age 70 in this instance, and certainly voluntary retirement before that. The third submission coming from Oropouche West, I wish to dissociate myself and the PNM from. That is the government from. That artificial intelligence will replace judges in Trinidad and Tobago. We do not support the UNC platform that judges will be replaced by artificial intelligence and by robots. It is a wild flight of fantasy, and I certainly cannot accept that submission. With respect to the shift system in San Fernando, as raised by Oropouche West, let me put on record. The records of the cabinet notes and minutes, demonstrate that it was under Attorney General Anand Ramlogan that the Buildings Committee of the Judiciary was dismantled. Not a single renovation happened to any of the court buildings. And I find it peculiar, if not boldface of Oropouche West, to chastise this government for building 125 new courtrooms, complaining about the facilities in San Fernando and elsewhere, when in fact it is a UNC government that did the Chaguanas Magistrates Court, spent tons of money on it. That San Fernando Chaguanas Magistrate Court, when opened, had no extra capacity and was deemed by the judiciary to be insufficient. But what was worse was Attorney General Anand Ramlogan buying a building in San Fernando deemed by the Ministry of Works to be entirely inappropriate to house a courtroom. That building was then condemned by the Ministry of Works. Millions of dollars paid for that structure under a UNC Attorney General. And today, Oropouche West arrives to lecture the PNM for occupying Tower D, complaining that we should give it to the International Financial Center. Why on earth would we want to give it to the International Financial Center when the number one issue is treating with the criminal justice system? You see, Madam Speaker, the honorable member, in an attempt, very charming attempt on her part, to be relevant to this debate, because she is charming, I mean that respectfully. The honorable member made joke of my constant reference to architecture. You know what architecture is? Architecture is a studied, careful planning arrangement which this government engages in. The opposite of architecture is squatting. And the member for Oropouche West and the UNC philosophy for criminal justice reform can be compared to squatting on state land. Build anywhere, do anything, take anything, no plan and no structure. So we make no apology for having an organized, systemized approach to the criminal justice relevant point. Madam Speaker, the honorable member made two other points I wish to address quickly. That is Oropouche West. Oropouche West complained about, and the member for St. Augustine as well, about the DPP's comments made at a particular event hosted by the judiciary. I was present at that event. I sat next to the judiciary, to the judiciary team and to the DPP. The DPP never said that there were no resources. In the abolition of preliminary inquiries, it is a matter of record that we opened, this government opened the DPP's office in Tobago at Lowlands Mall. This government is building out the DPP's office in San Fernando at Gulf City. This government is building out the Park Street accommodation for this DPP's office in Port of Spain, which will be opened in a couple of weeks. I just said Tobago. That's Lowland Mall's occupation. This government ring-fenced the legal fees and administrative fees for the DPP in the budget. This government ensured the hiring of more capacity, but the Honourable Member for Oropouche West, in touching upon the availability of prosecutors versus defenders, failed to pay attention that this government will deliver in a matter of weeks a public defender system. The building has been rented at Stanmore Avenue. 30 lawyers have been identified to be retained into that system. We are broadening the legal aid advice and authority, and we will birth, therefore, competent counsel when someone's defense counsel is not ready on 2 occasions or 3 occasions under the rules of court. The state will step in and you will get competent counsel and your case begins. You see, if you take the recommendations of St. Augustine, St. Augustine made a very bold thing to say it was the member for Siparia who started reviewing the age for retirement. Coulda, shoulda, woulda, 5 years, 3 months, absolutely nothing. In fact, the member for Point Fortin reminded me, it was Mr. Justice of Appeal Ulrich Cross, together with the member for Point Fortin, under Minister of National Security Martin Joseph, that began the full and complete review for the amendment to the age of retirement in the Trinidad and Tobago Defense Force and also in other areas. And importantly, I had a chance while sitting here because we've gone e-cabinet. Our cabinet is now on an iPad. And I had cause to call for the cabinet notes, etc. The only cabinet note that I found in relation to judicial improvements of the type that we are looking at, Madam Speaker, is the following. It is, in fact, cabinet note produced under Attorney General Ram Logan. It is Cabinet Minute 1851 of 2014, and that is solely and simply to ask the SRC to review the terms and conditions of the Executive Court Administrator. That's it. So I don't know what St. Augustine is proposing here today, but there are no records in actuality. Last point. The Honourable Member for St. Augustine said today we should cause the amendments to remove the 10-year restriction on judges coming off the bench from going back into appearances before the court. That is not a matter of law of primary legislation. There's no primary law to be amended. The recommendation is done by way of rules of the court, the Rules Committee. The Chief Justice just needs to be written to be asked to pass that provision. As Attorney General, I intend to take a note to the Cabinet. Having done the research on this, I invited the submissions of the Law Association. As San Fernando East correctly put forward, the Law Association has confirmed that the recommendation of 3 years is the appropriate recommendation, and we will get it done. I did say last point, but permit me to do this because I did speak with the Leader of the Opposition, who raised a very important point, and I'd like to give way for the Leader of the Opposition to put that point on the record.
Thank you, H.E. My question is whether you could have done a person who wishes to voluntarily leave before the age 70. Sorry, the question I asked you was, is this now mandatory, apart from the provisions in 136 for dealing with judges and some infirmities? If I decide to leave, can I do so before the age 70?
Thank the Honourable Leader of the Opposition, the member for Siparia. It's a very important point that the Honourable Member has raised, and I'm very happy that it's been put onto the record, and now I have the opportunity to lay the answer onto the record. In coming up with this proposal, we looked at a number of jurisdictions, Canada in particular, etc., where in fact there is a tiered system for going. So you can be at age 65, and then you can have the option to voluntarily retire at that age, or if you wanted to stay on, you can go to a later point, say age 70, and some jurisdictions actually have on a reduced workload basis. Unfortunately for us, the complication of the terms and conditions in that gap between 65 to 70 with a tiered system approach became very difficult. I remind us that this country didn't take very favorably to the increase in judicial and parliamentary pensions. We all know it had to be done. We all agree that it's been far too long that we needed to treat with those things. The complication arose, and therefore we went for the age 70. It is technically the mandatory age for retirement, as the member for Siparia has put it, but you have the ability to voluntarily go at any point in time. What we have done, thanks to the Minister of Finance, having improved the terms and conditions on retirement, pensions, and other aspects, you're now in brackets depending upon your length of service. So from day one to a particular year marker, there's one bracket of pension, and so you go in brackets. So the closer you get to age 70, let's say in the bracket 65 to 70, you're probably in the same pensionable benefit zone at 65 as you would be at 70. So we've managed to treat with it that way, thanks to amendments brought by the Minister of Finance. But I thank the Leader of the Opposition for making this interjection. I think it's a very important point brought by the Leader of the Opposition, and I hope I've done some justice to the answer. Madam President, Madam Speaker, forgive me, I was in Parliament yesterday in the other place. This is good law. It's long overdue. It's part and parcel of the amendments to the criminal justice system that we have brought forward in a very careful arrangement, and I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Constitution, Prescribed Matters Act, Chapter 102, the Interpretation Act, Chapter 301, and the Judicial and Legal Service Act, Chapter 601, be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Constitution, Prescribed Matters Act, Chapter 102, the Interpretation Act, Chapter 301, the Judicial and Legal Services Act, Chapter 601.
Attorney General.
Madam Speaker, in accordance with Standing Order 68-1, I beg to move that the miscellaneous provisions, Age of Retirement of Judges, Interpretation and Chief Judicial Officers Bill 2019 be committed to a committee of the whole.
Honourable members, the question is that the miscellaneous provisions, Age of Retirement Judges, Interpretation and Chief Judicial Officers Bill 2019 be committed to the committee of the whole. All in favour say aye. Aye. Any against? The ayes have it. This House will now go into the committee of the whole to consider the bill clause by clause. Members, it's now 4:30. We shall take the suspension now. We will resume at 5 p.m. Into the committee of the whole.